Listeners, I would like to begin my commentary on this matter by first of all thanking Justice Day, McDonald Bishop, and that for having, to my mind, establishing very firmly the fact that the Senate of Jamaica is a distinct and separate house of the Parliament of Jamaica. I think it was a long time coming because political leaders on both sides have used it as a matter of convenience, especially when they require vacancies so that they can fill various slots in cabinet and for all other intents and purposes to reward political activists and all the rest of it. We know the history of it very well. I'm very happy that the justices reinforced the fact that the framers of the Constitution never intended for it to be a political house. And in fact, in most countries, a Senate is a deliberative body far above partisan quarrels and controversy. That said, I do not share, and this is perhaps not surprising, I do not share the utterances and the proclamations and pronouncements of several individuals across the country, my co-host included, who have called into question not only the judgment, but the competence and validity of the leadership of Andrew Holness. Put simply, listeners, it is nonsense. And I will tell you why it's nonsense. The world over, constitutional courts, Supreme Court, courts of appeals have found actions, stipulations, legislations unconstitutional. It has never been the practice that anyone resigns as a result of that. In Jamaica, for example, when P.J. Patterson and the People's National Party government of 2005 rammed through legislation that would have altered the constitutional scheme of this country with regard to the final appellate court, the Privy Council, not Jamaica's constitutional court, but the Privy Council, the highest court of appeal as established under our current constitution, ruled his actions, the actions of the Attorney General and the actions of the Minister of Justice unconstitutional. Let's not forget that. No one called for P.J. Patterson to resign, either the leader of the PNP or as the Prime Minister of Jamaica. And he was found to have acted in breach of the constitutional scheme of Jamaica, and no one found it necessary for him to resign. Listeners, when President Barack Obama took his sweeping immigration policy just the other day, there have been several calls, yes, by erudite scholars of the U.S. Constitution for him to resign because they found that would have been an unconstitutional breach of his powers as the president. Listeners, if a court, and when the court rules on the matter, and if it is ultimately found unconstitutional, there is no basis, either in law or practice, for the U.S. president to resign. When Canada's Supreme Court just last week found that the government of Stephen Harper acted in an unconstitutional manner in preventing persons to exercise the right to die, no one, listeners, no one to my mind, and as yet I've read, has found that the government has to resign because they breached the Constitution of Canada. Put simply, listeners, this is routine. It is not an anomaly. It is not something strange. Only it has not been found in breach of any grand criminal law. Anyone who suggests that is being disingenuous, and as I said last week, the member referred to it, unfair. But I'll allow him to go in now. Mr. Chamberlain.
Listeners, if you are not easy to decipher, my co-host will mislead you, because here we have him giving us all these scenarios to justify, yes, what Mr. Holness did was absolutely wrong. What Mr. Holness did, and as the court said, was to came up with a scheme, yes, a scheme that would manipulate those who are put in office. This is not about any court rule, any government saying this should happen, and then the Privy Council or the higher court rule against it. This is Mr. Holness saying to members who he is going to appoint to the Senate, if you ever dare to veer away from what I as leader of this party, I said, this letter that is undated and unsigned will be the marching order. Yes? And that's where Mr. Holness went wrong. Mr. Holness went wrong. And having said that, listeners, let us look at the occurrences that came after. According to Mr. Holness, yes, in one of his release, he acted on the advice of Arthur Williams. He also went on to state that when the matter went to the court, he took those undated letters, the remainder, and he handed them over to the leader of opposition business in the Senate. Isn't that a clear admission that he erred? Isn't that a clear admission that he knew that he was doing something wrong? He further went on to state in this last release, listeners, that he acted upon advice and was guided by attorneys, more than one, at law. Now, we would like to know which attorneys advised Mr. Holness of this grave constitutional breach. And saying to you, listeners, it was a scheme. Yes, it was well orchestrated and it was well planned. They knew what they were doing. And let me be clear, listeners, Arthur Williams has no clean hands in all of this. He's a part of it. And only because he got hurt by the very same letter which he conspired to create that we see this in the court. And I'm saying to the listeners that what Mr. Holness did, he must be held accountable for that. And he said in his release, my overriding consideration as leader of the opposition was, in doing this, was to safeguard the spirit and intent of the Constitution. Yes, so that it would be in the best interest of the Jamaican people. I say to you, listeners, it's a farce, it's a fallacy, and it's a sham. And whatever release that comes from the office of the Prime Minister of the opposition, we should not take it seriously, because as they release these releases, all you're seeing is that they're sinking themselves into a deeper hole. What Mr. Holness must do is to take responsibility, because I've seen throwing all sorts of people under the bus. You must take responsibility. And as I said in my opening, listeners, he is a weak leader, because only a weak leader, yes, would rule by fear.
I'll say this, listeners. First of all, there is no scheme. Yes? There is no... A scheme suggests some intricate plot. Yes? Some grand conspiracy. That never happened. What happened? No, let me finish. Let me finish.
At the beginning of your opening argument, you said you agreed and you applaud the judges.
Oh, absolutely. Hold on. If you allow me, Allow me, please. I agree with the judges to the extent that they have, and I said that very clearly, enforced and affirmed the fact that the Senate of Jamaica is a distinct and separate house of the Parliament. I said that. I agree to them to that extent. I find that there was no scheme. The leader of the opposition, in seeking to secure, in his mind, the interest of Jamaica without, yes, secure the interest of Jamaica without having the government forced through legislation, without consultation with the people, decided some kind of safeguard was necessary. He was advised, and let me just make it clear, constitutional law is a matter of interpretation. It is a matter of interpretation. Yes? So there was never a definitive position on whether or not senators were elected or appointed, rather, for a full 5-year term. In fact, as I said, it has been a practice. It has been convention in Jamaica for it not to be that way. Let's be clear on that. So all the evidence in practice would suggest that what happened was constitutional. Now, we can argue about whether or not, as a conflict of loyalty, Mr. Holness was forced to take the drastic action he did. But for Mr. Chamberlain and his and those who would want to be detractors from Mr. Holness to create much ado out of this is disingenuous and it is unfair. Because, as I said, it is not that unusual. They have read all different kinds of things into what has happened. Listeners, to be simple, this is what happened. The leader believed that he needed to secure, yes, against a government intent on using its own legislative will to alter the constitutional structure of Jamaica. He may not have found that he could trust the senators who he had appointed, and I will concede that, and therefore it caused him to act in a manner that would have been far outside let me finish. Far outside of anything we would have heard of. Yes? Ultimately, he was doing that on legal advice, on constitutionally what he thought to be sound advice. The justices of the Supreme Court found otherwise. It is not unusual. It is not strange. There's nothing to be making this amount of fuss over. And if we're honest, listeners, people like Mr. Chamberlain are trying to use this as some grand political. They're trying to milk it. Mr. Chamberlain had probably 5 statuses per minute on this matter with all kinds of pronouncements. It's unfair, listeners. It is unfair. And let us be reasonable. He has apologized. He has expressed his regret, yes, for how it happened. And as I said to you, I concede that it may have been a crisis of loyalty that forced him. And that's an entirely different matter that can be addressed. But I do not believe, and I stand by what I said last week, that this in any way suggests that he is weak or incompetent. And any argument that tries to prove that is unfair.
Listeners, my quote and I will not agree on this very, very most touching of topic. But I will end by saying, you see in his opening statement, my co-host that is, said he agreed with the judges, and now to come to us and say it was not a scheme when the judges themselves, yes, said that it was, then he's contradicting himself.